Frequently asked questions about administrative wage garnishment on SBA loan problems. What is wage garnishment? Generally, wage garnishment is the ability to compel an employer to divert a percentage of a debtor's disposable pay toward payment on delinquent debt. It's traditionally been a complicated means to enforce collection. The process ordinarily involves obtaining a judgment in court and then going through a certification program on a semi-annual basis to continue justifying the garnishment. What is administrative wage garnishment? Administrative wage garnishment is the ability to divert a percentage of an SBA debtor's disposable pay without having to go through the court system. The Debt Collection Improvement Act of 1996 provides that the federal government can garnish the wages of any employee to satisfy a delinquent non-tax debt owed to the United States. With the recent codification of the Debt Collection Improvement Act into the Small Business Administration regulations, administrative wage garnishment can now be conducted by SBA against virtually anyone who has remained employed for 12 continuous months or more on delinquent non-tax debt owed to the agency. What is disposable pay? Disposable pay means that part of the SBA debtor's compensation, including but not limited to salary, bonuses, commissions, and vacation pay from an employer remaining after the deduction of health insurance premiums and any amounts required by law to be withheld. Amounts required by law to be withheld may include amounts for deductions, such as Social Security taxes and withholding taxes, but do not include any amount withheld pursuant to a court order. What is meant by delinquent non-tax debt? Delinquent non-tax debt means any debt not related to an obligation under the Internal Revenue Code of 1986 as amended, that has not been paid by the date specified in SBA's initial written demand for payment or applicable agreement, unless other satisfactory payment arrangements have been made. For purposes of AWG, the terms debt and claim are synonymous and refer to delinquent non-tax debt. What is meant by debt or claim? Debt or claim means any amount of money, funds, or property that has been determined by an official of the federal government to be owed to the United States by an individual, including debt administered by a third party as an agent for the federal government. Debt also includes accrued interest, administrative costs incurred in collection efforts by SBA or a lender participating in an SBA loan program, and penalties imposed pursuant to law or contract. When may the SBA initiate administrative wage garnishment proceedings? Whenever the SBA determines a borrower or guarantor owes a delinquent non-tax debt, the agency may initiate proceedings to withhold a portion of a debtor's wages to satisfy the SBA debt. What notice must the SBA give before beginning an administrative wage garnishment? 1. SBA will send a written notice by first-class mail to the SBA debtor's last known address at least 30 days before initiating garnishment. This pre-garnishment notice will inform the SBA debtor of the type and amount of the debt, SBA's intent to collect the debt by making deductions from the SBA debtor's pay until the debt is paid in full, an explanation of the debtor's rights, including those listed below, and the time frame within which the SBA debtor may exercise his or her rights. What are the SBA debtor's rights under AWG? The SBA debtor has the right to inspect and copy non-privileged SBA records related to the debt, enter into a written repayment agreement with SBA under terms agreeable to SBA, and have a hearing before an SBA hearing official or administrative law judge concerning the existence or the amount of the SBA debt or the terms of the proposed repayment schedule under the administrative wage garnishment order. However, the SBA debtor is not entitled to a hearing concerning the terms of the proposed repayment schedule if those terms have been established by written agreement under paragraph 2 above. When a request for hearing is granted, what generally happens? The SBA will have the burden of going forward to prove the existence or amount of the SBA debt. Thereafter, if the SBA debtor disputes the existence or amount of the debt, the SBA debtor must establish by a preponderance of the evidence that no debt exists or that the amount of the debt is incorrect. In addition, the SBA debtor may present evidence that the terms of the repayment schedule are unlawful, would cause a financial hardship, or that collection of the debt may not be pursued due to operation of law. How long does it take for a hearing official or administrative law judge to make a decision once a hearing is held? The hearing official must render a written decision within 60 days of the date on which the debtor's request for a hearing was received. If the hearing official's decision is not rendered within that time, and SBA had previously issued a garnishment order, SBA must suspend garnishment beginning on the 61st day. This suspension must continue until the hearing official renders a decision. Who issues the garnishment order and what form does it take? The garnishment order will be in a form prescribed by the Secretary of the Treasury and will contain the signature of or the image of the signature of SBA's administrator or her delegate. The garnishment order will contain only the information necessary for compliance, including the SBA debtor's name, address, and Social Security number, the instructions for garnishing the debtor's pay, and the address for sending payments. SBA will retain evidence of service showing when it mailed the garnishment order. What constitutes financial hardship? If the SBA debtor's wages are subject to a garnishment order issued by the agency, the SBA debtor may at any time request a review of the amount being withheld from the wages based on a material change in circumstances that causes severe financial hardship, such as disability, divorce, or catastrophic illness. The Code of Federal Regulations states the SBA debtor may send a request to the director of SBA's Loan Servicing Center in Birmingham, Alabama. However, it's not required that it be sent to Birmingham. For AWG proceedings in Little Rock or Fresno servicing centers, it makes more sense to send such requests to Little Rock or Fresno. Hardship requests must specifically state why the current amount of garnishment causes the SBA debtor financial hardship, and the SBA debtor must send documentation supporting that claim. If SBA finds financial hardship, SBA will decide how much and how long to reduce the amount garnished from the debtor's pay. SBA will notify the employer of any reductions. Can an employer fire an employee because of AWG proceedings? According to the regulations, no employer may fire, refuse to employ, or take disciplinary action against the debtor because of a withholding order issued by SBA. Does AWG trigger the one-action rule or other state anti-deficiency laws? AWG regulations contain the following, quote, "This section applies despite any state law," close quotes. SBA's receipt of payments under this section does not prevent SBA from pursuing other debt collection remedies. SBA may pursue debt collection remedies separately or together with administrative wage garnishment. The courts will be the final arbiter to determine if this language is sufficient to ward off any such defenses. Is there a deadline for pursuing AWG? Unlike actions pursued in court, there appears to be no statute of limitations on initiating AWG. However, it is possible to argue that the equitable doctrine of laches applies. Consequently, if AWG is initiated an unreasonable number of years after the loan went to default, the SBA debtor may be able to raise this particular defense. While there is no bright line for this defense, the Department of Justice's Financial Litigation Unit has issued an informal warning about pursuing AWG, quote, if 15 to 20 years have lapsed since the cause of action has accrued. For instance, the default date. Close quotes.